No, it's still not. Mic is working, sir.
Ma'am, you are audible.
Yeah, I am audible, but am I visible?
No, ma'am, your camera is not on.
Acha, acha, let me try. Huh? No, I can't see you also, sir. I can't. Yeah, yeah, now you are visible, sir.
Okay, camera नहीं on किया भाई इसलिए I'm not visible. करना पड़ेगा क्या मैम?
मैं फिर से ज्वाइन करती हूँ. Yes, sir. Sure, sure.
Hello, good evening. So, am I audible?
Yes, sir, you are audible.
Okay. So, madam will join shortly. She joined, but again, there's an issue within the video. So, she'll be joining again.
Okay.
Okay, sure.
Yeah, I think there's a problem here. I'll change the device, sir.
Okay, no problem. Yeah, sure.
Okay, sir. Sir, can you please email me the link so that I can easily join?
Okay, sure. Yes.
Okay.
Okay, madam, please, I have already sent you a mail. Please check the link.
Yes, sir. I'm trying from the another device. Let me just log in. I can't.
Okay, okay, yeah. Now you are visible, yeah. Hello. Utsavi, let us start.
Okay, sir. Good evening, everyone. I invite you all to embark on this transformative journey of professional growth, collaboration, and innovation. Welcome to the first ever 1 month national level online faculty development program on teaching laws in the 21st century, a collaborative effort between Law Teachers India and Gujarat Maritime University, Gandhinagar. Let us embrace the challenges and opportunities of the 21st century in labor laws, guided by the expertise of Dr. Asha Verma, ma'am. Ma'am is currently serving as an assistant professor of law at Gujarat National Law University, Gandhinagar, Gujarat. Has more than 12 years of teaching experience. Apart from teaching, she has also heading the GNLU Center for Women and Child Rights and the member of GNLU Center for Environment Law and Sustainable Development. She is the editor of 4 books in the area of environmental law and maritime law and has authored 1 book on criminology published by a reputed publisher. She has keen interest in labor law and industrial laws, constitutional law, environment law, administrative law, media and telecommunications laws, health laws, refugee laws, and gender justice and child rights. She has participated and presented research papers in more than 30 national, international seminars and conferences. She has also published research papers in national journals. She has worked on various projects with NCW, Ministry of Women and Child Rights, and Government of Gujarat on research areas related to gender justice, child trafficking, migrant women, right to education and child labor. I welcome you, ma'am, on this platform to share your knowledge. Over to you, ma'am. Sir, ma'am is mute because she's not a co-host.
Now I'm audible, I think.
Yes, ma'am, you're audible.
Okay. So thank you, Utsavi, for the very kind introduction. And at the outset, I'm really very thankful to Law Teachers of India Group, as well as GMU, Dr. Kalpesh Gupta. Thanks a lot for inviting me and giving me this opportunity to share the views on strategies on how to teach the labor laws in the law schools of India. This is indeed a very good initiative, as the anchor of the program has already stated. That is a very good initiative that we all have collectively taken. And this will give us the opportunity basically to learn from each other, because we belong to the same fraternity. And by discussing all these strategies for teaching different subjects in law schools in India, I think this is a very good opportunity that we have got for learning from each other. So I am really very, very thankful to the organizers, especially Dr. Kalpesh Gupta. Now, moving ahead with the important task, important responsibility that has been assigned to me, I'll just start sharing my PPTs. Is it visible, Utsavi?
Yes, ma'am.
Okay. So, a very good evening, dear participants. As the anchor of the program has also informed, that this is the session where I'll be dealing with the strategies for teaching labor laws in Indian law schools. So, at the outset, I would like to emphasize upon the very, very significance of the very important nature of the subject itself. Because the subject is actually this labor law, the area of labor law is actually covering the vast working force of India. And that is why it is actually dealing with various aspects connected with the labor force, the working class in India. That is why it is very, very important. And we all know that if we look at the statistical data available, there is a total of around 500 million workers in India, and that is the second largest after China. Uh, the labor laws, the industrial laws in India actually covers this very vast workforce. So this itself shows us, this itself reflects that how important this subject is, and especially for law students, for the law teachers, this is one of the very important branch of law for which we should develop our understanding. And out of this total workforce also, which the statistical data shows, we can very well understand that the workforce is again divided into the organized sector, unorganized sector, marginalized workers. Then, agricultural industries are also there, wherein it consists of around about 41.19% of the total workforce, which is engaged in this agriculture industry. And then we also have the other industrial sector, where also there is around about 26.18 of the total workforce, which is engaged. And then again, the bifurcation is in accordance with the workers, the workforce, which is engaged in the service sector. So there also we can find that as per the statistical data available, it's 32.33, approximately 32.33% of the total workforce, which is engaged in the service sector. So this data itself shows, it reflects that when it comes to the labor laws, when it comes to the industrial laws in India, it is actually covering this variety of workforce, the heterogeneity in the workforce, and therefore the subject becomes very, very important. Now moving to the scheme of the presentation that I'll be covering. Utsavi, is it okay, or I should increase the font size or make it in the presentation form? Is it okay now? I think it's much more better now.
Yes, ma'am.
Okay. So now, let us just have a quick look on the scheme of presentation, the areas, the points that I'll be covering in this 1 hour session. And definitely, wherever you feel, you can also provide your input that will develop us a better understanding on this particular area of law. So in this presentation, I will be covering the significance of the subject, the objectives of the course. If we are framing the syllabus for teaching to the law students, then with what objectives the syllabus is to be framed, what should be the expected outcome, what we are expecting from the students, what should they learn. Then as a law teacher, labor law teacher, as a student of labor law also, even I have found various challenges in teaching the subject. So that will also remain the part of the presentation. Then what should be the ideal pedagogy, teaching pedagogy that we can adopt, especially when it comes to the labor laws, and what all laws are to be included as a part of syllabus, which is spread in 2 semesters. Then the different other courses that can also be designed in align with the labor laws, and what should be the evaluation and assessment mechanism when it comes to this important subject. So this will be the scheme of presentation. Now starting with the significance of the subject. So as I have clearly told you that the subject is very, very significant because it is covering the vast labor force in India, which is again very, very heterogeneous, and the workers also, the workforce also is divided into various sectors. Now when it comes to the areas that the labor laws covers, so labor law actually covers various areas relating to employment law, and it is applicable to any organization, whether it's a private establishment or it's a government establishment or it's a manufacturing unit or it is any trading organization. These are the laws which are applicable even to the shops and establishments, where the state governments also come up with their state enactments. So as far as the area of labor law is concerned, it's very, very wide and covers each and every of these establishments. Now, what all are the subject areas which are covered under labor laws. So there also we can very well understand that it's a very vast subject because it actually addresses a lot of aspects, like the administrative rulings. It also covers the employment related laws, the standing orders which must be applicable to any establishment in order to bring the uniformity in terms and conditions of employment. Then what are the procedures to be followed when it comes to framing the standing orders? Or sir, there is one comment, there's one
No, you are audible.
audible. Okay, okay. Yeah. So I was telling you about the different aspects covered under labor laws, like the administrative rulings, the standing orders, the procedure for drafting the standing orders, how to bring the uniformity when it comes to the working conditions. These all, then the compliances, the various compliances that are required to be made by the employer of any organization. That is also covered under the existing labor laws. So area is very wide. What are the legal rights of the workers? What are the obligations on the part of the employer? How to make the workplace very workers friendly? How to ensure that there is a workplace safety? So the area, the coverage is very, very vast. When it comes to any such establishment where the labor laws relating to industrial relations are applicable, as an employer, he has to ensure that the industrial relations are regulated, the unionization is happening, the unions are formed, and the certification of unions are also done. Then the labor management relations are also governed, the collective bargaining take place. Then there is no unfair labor practice at any establishment, and very importantly, the health and safety of the workers. Other than that, the employers, they have to comply with all the labor laws, and they also have to ensure that the employment standards, they are also effectively implemented, first of all laid down and then effectively implemented. Then it also covers various the employment related conditions, like what should be the working hours for the workers. Then what should be the provisions relating to annual leave, the normal working hours, the overtime payment if it is to be made, and in case if there is any unfair dismissal, then what is the disciplinary procedure to be adopted, the principles of natural justice to be followed, and the action to be taken by the appropriate authorities. Then other than all these aspects, the labor laws also covers the procedures relating to layoff, retrenchment, lockout, and to ensure that if there is any such layoff or retrenchment, then the workers are also compensated in accordance with the procedures, the conditions which are laid down under the Industrial Disputes Act 1947. So all these issues, they are very well covered under the existing labor laws. Now with this, what I was trying to emphasize is that the coverage of labor laws is very vast. It covers these areas, these aspects relating to the workplace, and the labor welfare, that also remains one of the basic principle when it comes to especially a democratic setup, when it comes to the constitutional setup. So our labor laws also ensure that those values are also very much protected. Now, when it comes to the role of the labor force in India, it has played a very important role when it comes to the growth of the economy of the country. And in this change scenario also, wherein we have seen that especially after the corona crisis, the problems of the migrant workers, that was also very well brought to the notice of the government, that even though we have a plethora of labor legislations which talks about labor welfare, which talks about regulating working conditions of the workers, then also there are certain such shortcomings, such lacunas in the labor laws. And therefore, the migrant workers at the time of that corona crisis, they had suffered a lot, wherein they had the loss of livelihood, and there was loss of the accommodation also, no place to reside, no employment available, no food available. These were the basic human rights that were violated at that time. So despite of having a very old law, the migrant workers actually had to suffer. No, now we can very well understand, that we have so many labor laws, so, different areas. These labor laws covers there is a great contribution of the workforce in India when it comes to economic development of the country. But then also there are certain shortcomings, certain lacunas in the existing labor laws. And here the need comes wherein our students and we ourselves are also to be sensitized before the problem regarding the problems relating to labors in India. And this is how the subject becomes very important, and this is how the subject is to be taught, so that we can also identify the shortcomings, the lacunas which are there in the existing law. That is why labor sensitivity is also very, very important. So when we are actually deciding the syllabus, the modules that we have to cover as a part of our syllabus, then we have to ensure that in the beginning itself, in the initial classes itself, if we are able to generate that sensitivity towards the working force in India, the problems that the working force in India are facing, I think we will be able to gain the interest of the students. Because I, as a labor law faculty, and I hope my colleagues who are attending this session, they also might have somewhere found it very difficult to generate that interest amongst the students. So what I feel, why I was telling you about all these backgrounds, that subject is so important. So much of workforce it is covering, so much of contribution that the workforce in India is making. It's not only that the workers who are working in the industry or an organized setup, they are only contributing. On contrary, you will find that the workers, the 90%, more than 90% of the workforce, which is engaged in unorganized sector, their role in the growth of national economy also cannot be ignored. But then also, when it comes to the laws relating to protecting the rights of the unorganized sector, we all know the reality that we are failing somewhere. Although the efforts have been made by these new labor codes, but they are also not yet notified. It is still in process. So we can very well understand that it's the unorganized sector, more than 90% of the population, workforce, which is engaged in unorganized sector, we are not able to provide them ample protection which is needed. Therefore, the students of labor law, they are to be sensitized about the problems, especially of the workers who are working in the unorganized sector. So on one hand, this labor sensitivity to be generated amongst the students. On the other hand, when we are studying labor laws, definitely we have to tell our students, we have to teach them about the constitutional provisions also. So behind every law that we study, and especially when it comes to labor law has its foundation in the constitutional law only, isn't it? Many of the provisions, starting from the preamble itself to many of the fundamental rights, starting from Article 14, Article 16, Article 21, Article 23, Article 24, and then are directive principles of state policy, especially Article 39, 39D, 43, 43A. These all are the very important constitutional provisions which are basically the foundation for our labor laws. So when we are teaching the subject to our students, although these multiple labor laws, they are also to be the part of the syllabus. On the other hand, these constitutional safeguards which are available to the labor class, they are also to be taught very well, because this will give them the basic understanding of the constitutional protections which are available to the working class in India. Now, along with these constitutional provisions, what is next very important thing to be taught to them is about the judicial intervention. So, when we talk about the judicial intervention, we have some very, very important landmark cases through which we can understand that how judiciary has played a very important role when it comes to protecting the rights of working class in India. So for that, a few of the very leading cases that I can just tell you quickly, like this pavement dweller quick case, right to livelihood, Olika Tellis. Then Damayanti versus Union of India, right to form the union and association. Then Vishaka guidelines. Yes, that's very, very important for our students to learn. Uh, Vishaka versus State of Rajasthan, how the obligations have been laid down upon the employer to ensure that the workplace is safe for the women employees. Then T.K. Rangarajan versus State of Tamil Nadu, important case regarding right to strike by the government servant. These are few landmark cases which are to be taught. Two other very important which I would definitely like to cite here: Bandhua Mukti Morcha and another People's Union of Democratic Rights versus Union of India. Now our base our foundation classes only, our preliminary, our initial classes only should start with these important case laws, so that the students can very well understand that on one hand we have multiple labor laws, we have plethora of labor laws, around about 40 central legislations and more than 200 state legislations. On the other hand, there are constitutional provisions, and the judiciary has also played a very important role. So that judicial intervention will actually help in bringing the sensitivity amongst the students, and also they will appreciate the role played by our apex court. So that is required to be taught in the initial class only. Then when I'm talking about significance of the subject, definitely the subject is very, very significant, because as an employer, or even when we are an entrepreneur, there's a new establishment that one would like to start, there are certain statutory compliances which one has to make. And these statutory compliances are laid down in these multiple labor laws, which we as a law teacher should definitely teach to our students, so that they can understand the various statutory compliances laid down under various labor laws. So now this is about the significance of the subject. Other than that, here only, I would also like to emphasize here that when it comes to the labor law, although every subject is very interdisciplinary in nature, law cannot be studied in isolation. And I hope you all will agree with me. Now, especially when it comes to the labor law, the subject knowledge of other areas of law which must be there is also a little bit of knowledge of the provisions under Indian Contract Act, and as I said, constitutional law, and also certain principles of administrative law. That must also be known to you, known to the students, and that should be included as the part of our curriculum, because labor law is such a subject which definitely cannot be studied in isolation, and all this integration is very much required. So what I said constitutional law, the provisions that I already have told you, administrative law, contract law provision should also be known to the students. So that should be included in the syllabus. And yeah, we also cannot ignore the important conventions, treaties, and the Universal Declaration of Human Rights. Certain understanding, some understanding of these subjects are also required, because it is very, very interdisciplinary in nature. So this is all about the significance of the subject. Now moving to the next part of our discussion, that is about the objectives. With what objectives we should frame, or we should draft our syllabus, and what all must be the objectives of the course. So when it comes to the objectives with which the syllabus should be framed is, number one, the what should be the approach to the labor law and industrial jurisprudence. Here I'll say that when it comes to the approach to labor laws and the various principles under industrial jurisprudence, we can teach them about the principles of social justice, then social equity, then national economy, then the concept of this social justice, then equity, equality, and national economy. These are few very, very important principles that are to be taught. And when it comes to the approach to labor law, yeah, that is definitely something which should be made a part of our syllabus, so that these students can understand the different approach to labor law and how the approach has kept on changing with the developments happening in the society. Because if you look at the historical period, especially the period after the First World War, Second World War, after Industrial Revolution, the approach to labor laws has also changed. So the objective must be to make it clear to the students that how the approach has kept on changing and what are the various principles of industrial jurisprudence. Then yes, as I said, that the relevant constitutional provisions which are there to ensure the protection of the labor and the effective implementation of the labor laws. Then the different dimensions of socio-economic problems which are faced by the laborers in India and other countries. So that comparative study, if it is also one of the objective with which the syllabus is drafted, that will also help us, to make our students understand about the labor force in different countries and how, in accordance with the socio-economic conditions there, the laborers face different kinds of problems. So that clarity must also be there with the students. Then the international labor standards laid down by ILO for the betterment of workers throughout the world. That is also one of the objective which must be fulfilled with the help of the modules that we have decided in our syllabus. Then also the student should be able to critically analyze the labor legislations. So when I am teaching the subject, like suppose I am just teaching the Industrial Disputes Act only, and when the provisions are there regarding layoff, retrenchment, and lockout, then I make sure that they are able to critically evaluate the provisions laid down under ID Act, the procedures laid down under the Industrial Disputes Act, whether every kind of this termination of services can be said to be retrenchment or not. What are the conditions laid down there? That analytical thinking needs to be developed. So every law that we are teaching, whether it's the Industrial Disputes Act, or we are teaching the Trade Unions Act, where there are the concepts regarding this collective bargaining and all, we teach it along with the act. So how the what is the position of collective bargaining, how far it is successful in India, if we are not getting that success as compared to other countries, then what are the problems? That critical analysis is required to be done. And I think, what I feel personally, when I am teaching this subject since long, what I have found is that this is a subject which will actually develop that critical thinking amongst the students. There are various areas. I just told you about two examples regarding collective bargaining and the provisions relating to layoff, retrenchment, lockout in the Industrial Disputes Act. What about the Contract Labor Abolition and Regulation Act, which was enacted in the year 1970? What is the present scenario? What about the dispute relating to automatic absorption of the contract labor? Isn't it? So many problems are there connected with the contract labor itself. And even the law of 1970 is not able to deal with various such issues. And then we, along with this, developing this critical analysis amongst the students, they can also do a comparative study, because contract labor is not a phenomena in India. It has been in practice in other countries also. So that critical evaluation, that critical analysis need to be done by the students, and that can actually help them to have better learning. Labor law is such a subject which can develop that critical thinking amongst them. Now, yeah, then the various forms of exploitation, that is also increasing. And with the change in society, especially when we look at the era after globalization, privatization, and liberalization, so that also needs to be critically evaluated by the students of law. They should be able to understand that how, when it comes to the forms of exploitation, that has also kept on changing with the changes happening in society. So we can very well teach them in a chronological order, or whatever developments have happened in the society. The phases that I just told you, the period during the First World War, during after Second World War, after which there was a lot of reconstruction which has taken place, the period after India gained independence, and then the period after globalization, privatization, and liberalization. Then, due to emergence of SEZs and EEZs, what are the kind of problems that the laborers in India are facing? If that can also be one of the objective with which we are deciding about the contents in our syllabus, definitely it will help our students to have better learning, and they will be able to have, a very multidisciplinary approach, which is basically the object which can be fulfilled with this subject. And also to understand the need for reforms in the existing labor laws. So when I teach the subject, I definitely in the initial class only include the 5-year plans, and also the reforms which were suggested by the first commission on labor and the second commission on labor. So through this understanding of the important recommendations by these two commissions, and also the important principles laid down through our 5-year plans, the students get the understanding that what had been the pace of reforms, because we have now these codes which are not yet implemented, which haven't yet come into effect. So they should develop that understanding that in the past also, what were the efforts made by the government, and what led to, those kind of reforms to be required. So that understanding is also required, and they will be able to appreciate that whatever were the recommendations by the second National Labour Commission or first National Commission on Labor, whether they have got some strength through this codification process or not. Not only these codes, but from time to time, the state governments also keep on bringing the reforms in the labor laws. So what efforts have been made by the various state governments when it comes to labor law reforms? And that's a very continuous process. We will find the changes we will find the reforms in the labor laws, whenever there is any such need, wherever there is any such need. Like, I'll give you example. After this COVID-19 also, after this pandemic also, in fact, during that period only, in 2020, April and May 2020, there were a lot of reforms by few of the state governments. Although the situation was such wherein it was not the major reforms required, but in light of that whatever financial loss the industries have suffered, wherein they just wanted to cope up the situation so that they can start their business again with the same speed. The Some of the state governments, they had brought certain reforms in their labor laws. Like, if you take example of state of Madhya Pradesh, state of Uttar Pradesh, state of Rajasthan, Gujarat, they brought major changes in their labor laws. So that reforms, why they were required and what impact these labor laws may have on the economy, and especially on the workers or on the employers, that understanding is also very much required for the students. So from time to time, we should keep on updating them about all the reforms which have taken place at state level also. Not only the codes are to be taught, but these state reforms from time to time are also to be updated to the students, because after all, they have to join any law firm, or they'll be practicing, or they'll join the judiciary, or whatever career they will opt for. I think labor law, they always have to, somewhere they have to deal with any such problem. So definitely that sensitivity is also required, that updated knowledge information is also very much required. So these are few of the objectives with which I think we should frame our syllabus. Now, coming to the expected outcome, with these objectives in mind, the modules that we have decided which can fulfill the objective of the course, what will be the expected outcome, what we are actually expecting from our students to learn. With these objectives, we will be able to develop the conceptual clarity regarding this subject, and they will be ready to face the real life situation, because labor law is such a subject which is different from other branches of law. Here the students actually, they learn to remain down to earth, and they actually understand the practicalities of life, real life situations. So that conceptual clarity they get, then they are also able to, they should be able to understand about the role and relevance of International Labour Organization, because as I told you that we just don't have to teach them the national laws, but we also have to teach them about the international labor standards laid down by ILO. So the role of ILO, the relevance of International Labor Organization in Indian legal scenario, that will also be very well known to them. They will be able to identify the rights of the employees, and they will also be able to understand the active role that the judiciary is playing when it comes to protecting the rights of workers in India, and also balancing the interest between protecting the rights of the workers and safeguarding the interest of the employers also. So we have some such judicial pronouncements also, which very clearly show that the judiciary has the very balanced approach. Now coming to the other expected outcome of the course, they will also be able to analyze the significance and role of trade union, how the trade unions can play a very important role in settlement of disputes, and also how the collective bargaining can also help in negotiations and dispute resolution. So this will be the expected outcome. Now, as I told you that as a law teacher, as a law student, I face lot of challenges when it comes to teaching the subject, and I hope you will also agree with me. In case if you can add something to this, I will be very happy. So now coming to the challenges in teaching the labor law. So one of the challenge is regarding the evolving new concepts. So the concepts like the gig economy, the concepts like freelancers, the concept like platform workers, the concepts like fixed term employment. These are new evolving concepts, which I think we have to make our students aware so that they can understand it, because they will later on they have to face the world, and they have to enter into all these engagements, wherein if they do not have the knowledge of these developing concepts, definitely they won't be able to survive. So therefore these evolving new concepts, and especially the situation is when they are not being covered under the existing labor laws. Only the codes are covering the gig workers or the platform workers, or the fixed term employment. These are the terms which have been defined under the new labor codes. But we as a labor law teacher, when we are teaching the existing labor laws, and if our students ask about all these, and they are going outside also, they are doing higher studies in foreign countries also, so all these concepts, they are very well regulated in other countries. Now when they are going there, they face difficulty, and then they call us that what is this, and why we haven't studied it, and what is the law regarding it. They definitely want to know, because the students nowadays, they want to remain very very updated, isn't it? So these kind of evolving new concepts, and then some such very very confusing terms which are there, like the word like workman, employee. Why the labor law, and under some of the labor laws it is the workman word defined, and why under the other labor law it's the employee word which is defined. So the students must have that clarity, that why a particular labor law has defined the word workman, and any other labor law is defining the term employee. What is the difference, why it is so, isn't it? So that differentiation also is to be very well taught to our students, and it becomes challenging for us. What is the difference between workman and employee? Although we are expert to teach them, but it is that clarity is to be brought amongst the students. Then why it is labor law, why can't it be employment law? So is it synonym, it can it be replaced? So these kind of queries, they definitely come to the mind of the students, and as a labor law teacher, it becomes challenging for us to keep on dealing with these terms and explaining it to them, especially when it comes to new concept. And then the problem is there, because we have plethora of labor laws which we have to deal. So that is also one of the challenge, that what laws to be included and what should not, because the students, when they join the law firms or when they are interning, they have to deal with such laws also which we were not able to cover because of paucity of time, which we in 2 semesters only we have to cover, and there are so many labor laws. They actually face the problem in accordance with the matter which is there before them. So it becomes difficult for them to bring that conceptual clarity regarding each of the evolving concept also. Then gender inequality, that is also one of the challenge which we all agree that it is there. And when we look at our labor laws, although the particular labor laws are there which ensure that there is gender equality, when we talk about Equal Remuneration Act, yes, this is the law which ensures that there is equal remuneration for the same work of similar nature. But that gender inequality, that is very well vigilant, and that causes a hindrance in the growth of our national economy on one hand. And that is one of the difficulty that we also face when we are teaching our labor laws. Coming to the new wage code, now you must be thinking that why I am putting it as a challenge. Because it is in fact making our work easier. Instead of teaching so many labor laws, it's the new wage codes. Oh, by mistake, I have written new wage code. I'm so sorry. It's about new codes. It's not wage code. I'm so sorry. I'll change it. So new codes, what I am intending to say is the challenge is also about new codes. So now, as I said, that you must be thinking it is making our work easy. Why I am quoting it as a challenge. So my dear colleagues, what I feel here is that on one hand, the codification has reduced the multiplicity of definitions, and it has also reduced the multiplicity of labor laws. But on the other hand, when it comes to the different terms being used here, like if you look at a particular code, there also the word workman and the employee both have been defined, isn't it? And there is also the insertion of some new terms. Somewhere it's only the older provisions which have been brought here. So, as a law teacher, we have to make it very clear to the students that what changes have been brought by these four codes. What are the differences and what are the similarities? If any new term has been used here, then what you can say reason behind it, isn't it? What is the justification behind it? So teaching these codes will also be challenging for us, because we cannot simply ignore the existing one. We have to keep on teaching them through the method of comparative comparison. So that will also become challenging for us, although I mean with the codes coming into effect and then in practice, I think the things will become easier. But till then, that's a challenge. We have to make it very clear to the students regarding the reason why this change has been made, or in case if it has remained intact, what is the reason behind it. Then one more challenge is that we have a class wherein we have the students with different perspective, in sense that they may have different careers that they have decided, and the approach of the students may also be different. Some may have the approach of being very employer friendly, and some may have the approach of being very sensitive towards the problems of the workers. So as a teacher, when we have the students sitting in the class with different perspective, wherein they have different decided about the different career prospects, and also the approach is also different, it becomes challenging for us to make them sensitize, to tell them what is wrong and what is right, to bring that awareness regarding the background in which these labor laws were enacted. So if we are able to tell them the background of a particular law, I think they will be able to appreciate that why a particular law is made applicable to a worker, why a particular law is using the word employee, to whom the protection has been provided, why there are no such protections being laid down for the employer, why the law itself seems to be very much workman friendly. So for that, we have to tell them the background, that what were the sufferings of the workers. When we talk about the minimum wages, it was basically to protect the sweated labor. So in the light of giving the protection to the workers who are engaged in the manual labor, this minimum wages act was enacted, isn't it? So that background of every such labor law is to be taught to every student, so that even if they have a different perspective, they can get that knowledge, that awareness, that sensitization can happen. So these are few of the challenges that I have identified, and definitely you can also help me in identifying any other challenge that you might be facing when you teach the subject. Now, coming to the pedagogy, the teaching pedagogy, that will be very ideal when we are teaching the subject like labor law. So, what pedagogy I use is firstly the lecture method that we all follow, then the presentations by the students. That can also be one of the very good way of knowing the views of the students, because it should not be any of the subject should not be taught by one way process. Students interactions must be there, so that may be by the presentation by the students, that can be during the class hours only, that can be found very effective when it comes to the subject like labor law. Then because once we have already told them the legislative provisions and all, I think the views, the opinions of the students also matters, and regarding certain topics definitely they can also present in the class. Then participative and interactive method, yeah. And then with the labor law there is one more very this added advantage, and it is that there are so many videos, so many good documentaries which are available, easily available on the YouTube, and I generally practice it in my class, and I have found the results very good, because the students, they actually understand the problems of the particular class of worker, or whatever is the theme with which the documentary is being if it is they shown in the class, then they very easily grasp the concept, and also they are able to understand the problems. So documentaries and videos, since it is very easily available in the area of labor law, that can also be a very effective mode of teaching, which I think we all can exercise, and I'm using it, and I have found the results very positive. Then since the subject is such where the conceptual clarity is also required, some description is also required, as I told you in the objectives of the course only, that the analysis, the analytical approach must also be there amongst the students. It's the subject wherein we can add various practical exercises also, and the legal aspects are also to be taught to the students. So these are this is the pedagogy that I generally use for my just teaching the subject. And then what else I have found as a very effective mode is to discuss the research papers with the students. So what I do is I send them the research papers in advance, because there's a lot of material available, especially in our subject. So whatever research papers are available, like if it is a contract labor, the papers are already available, wherein very good scholars, they have added very good this literature in this particular area. The problems of unorganized sector, gig workers, platform workers. So I send them the research paper, and in the next day we do the discussion. That is one very good way. Then what else can be the mode of teaching is through empirical studies. So empirical studies also in many of the areas relating to labor law, that is already done. So if I teach through that empirical study conducted, I have the authentic data with me. So students are really able to appreciate those research studies being conducted in different areas, and through that they develop better understanding, that actually becomes a base or foundation for any of the topic that we are studying. So for most of the topics, the empirical studies are available, whether it's the migrant workers, or it's a problem of bonded labor, or it's a problem of contract labor abolition, or it's a problem relating to employment injuries. That is also one of the area wherein a lot of this documentaries and videos are also available, and also a lot of empirical study is also conducted. So these studies actually give the base, the foundation for our discussion in the class, and that I encourage student also as a part of their continuous evaluation. If a group of students is very much interested, I assign them the task of doing an empirical study. Taking a small sample, they can very well do the empirical study. So that is also one of the very good way of teaching and learning. Discussions actually bring some interactive this participation of the class, so that is also very important. And then yeah, whatever are the legal implications that needs to be connected with the whatever provisions of law that we are teaching. And then when it comes to the subject of labor law, yeah, case study helps a lot. So even I have my own collection of the case laws, the leading case laws. So that also helps the students to understand the subject very well. And there are some such cases wherein it has given a very good interpretation of some of the concepts under the labor laws. Like, I'll give you the example of this Bangalore water supply case. So Bangalore water supply case, every law teacher teaches when the teacher is dealing with the definition of industry. So that case study wherein the triple tests were laid down in order to interpret the word industry, that becomes a very good source of information for the students. They are able to develop that critical evaluation, and the analysis also they do through that case laws only. So case study, especially when we are teaching the labor law, and then when so many developments happening, the various dimensions are changing, whether it's the industrial relations or any other aspect of the labor law, since the dimensions are also changing, approach is also changing, definitely the case studies helps us a lot. So this is the teaching pedagogy that can be ideal when we teach the labor laws to our students. Definitely you can also provide me the suggestions here in case if you adopt any other methodology that we can share with each other. Now comes what should be included in the syllabus. So although we all know that labor law is such a vast subject, so many labor laws at central level, and also state governments have enacted so many labor laws, multiplicity, plethora of labor laws. But what should mainly be included in the syllabus in a systematic manner? Because here we have to make sure that the students get the understanding of all the relevant laws, whether they are preparing for judiciary, whether they are going to join the law firm, whether they want to practice in the labor area of labor law, or they want to join any services like that of enforcement officers or otherwise. They should not feel that we were not taught this in our class, which was very very important for us, which would have helped us. So we should, as a teacher, we should try our level best to incorporate those important laws in our syllabus, which will be helpful to them whatever career they join, although it's again very very challenging. So we should start with the historical background. That's very very important, because we have to actually tell them about the background in which the labor laws have evolved. So that I always keep as the first module of my syllabus, wherein I teach them about the historical background and all, what were the problems of the laborers, and how the they were exploited, rights were violated, which led to enactment of all these laws. Then constitutional background, that definitely should include the provisions under the under part 3 and part 4 of the Indian Constitution, and along with that the leading cases, the apex code, where when it has intervened in protecting the rights of the workers in India, that should also be the part of our syllabus when we are teaching labor law. Then industrial jurisprudence, certain principles must be included. Like I told you, social justice, that is to be taught, because all our labor laws, they basically ensures social justice to the workers. So what is that concept? Although they have already studied under Indian Constitution, but we as the labor law teacher, we have to, mainly focus on the principle on the basis of rights of the working class in India. Then yes, the study will be incomplete, because there are various aspects that the labor law covers, and one very important aspect is to regulate the industrial relations. So before we actually move on to the laws relating to industrial relations, it becomes important for us to teach them the concept of industrial relations. What industrial relation is, who are the parties to industrial relations, what role the state plays when it comes to regulating the industrial relations, how the approach to IR is changing, what are the various dimensions of IR, what are the various theories relating to industrial relations. If that is made clear to the students, I think they will be able to appreciate the provisions under different laws. So that conceptual clarity regarding IR, the significance of IR, scope of IR, parties to IR, if that is made very very clear to the students, then they will be able to understand the laws very easily. Then comes the international labor standards. So what important role ILO has played when it comes to bringing the uniform labor standards through conventions and recommendations, then that definitely should be the part of our syllabus when we are teaching labor law 1 only. Okay, so if they are very clear with these international standards in first semester itself, first semester I mean part 1 labor law, so this will actually help them in part 2 of the labor law also. ILO standards, I mean, we cannot simply ignore these important principles which are laid down here. Then after developing this conceptual clarity, next is to then venture into the legislative enactments. So for that, we should start with the laws relating to industrial relations, wherein we can teach them the Trade Unions Act, the Industrial Employment Standing Orders Act of 1946, and ID Act. These are the three main laws which are to be taught under this module. Then the laws relating to wages, where we can mainly focus on the Payment of Wages Act, Minimum Wages Act, and also the Equal Remuneration Act, and also the Payment of Bonus Act. So these are the laws which necessarily to be included under law relating to wages. And what I have experienced, what my students, they keep on reporting to me after they join the law firms and all, they actually, find the issues, the matters relating to industrial disputes under ID Act, wherein any retrenchment has taken place, which was illegal, not in accordance with the procedures of law, or any such layoff declared by the employer, or the problems relating to notice under ID Act, section 33C of the ID Act. So when we are mainly focusing on these law, definitely this is going to help them whether they are joining the law firm or they are practicing in the area of labor law. Then laws relating to wages, wherein we have to focus on these laws that I have just told you. Here also the problems are basically because they join some corporates, some companies. So there the payment of wages question doesn't arise because it has its applicability over certain class of workers. But definitely they have the issues regarding equal remuneration and the payment of bonus also. So this if they have got clear understanding on the law relating to wages, this will definitely help them. And if not in the law firms or the corporates that they are joining, definitely if they are applying for the judiciary, if they are appearing for any such civil services exams, these are some such laws which will definitely help them during the interviews, and also when they are writing the descriptive answers. These this law knowledge of these laws will definitely help them. Then the laws relating to social security, here also mainly we have to focus upon the Compensation Act, Employees Compensation Act, and the other laws relating to gratuity, and also ESI, EPF. Because what I have experienced is the students generally they get the matters regarding this only, whether it is matter relating to gratuity, or it's the matter relating to insurance, or in some of the cases the dispute or the claim is regarding the compensation under the Employees Compensation Act. So these laws are required to be included. Then comes the occupational health and safety. So for that we have the Factories Act, which is required to be taught to our students, and then the other laws relating to occupational health, safety, and welfare of the workers. Then there are some certain other issues like that of a Contract Labor Abolition Regulation Act, child labor, the problems of marginalized laborers, that also need to be taught to them. And then the comparative study is that is something which is required to be included in our syllabus. Why? Because as I told you that the students will go for higher studies in other countries, and definitely there they will find some difficulty when they know the Indian law only. So although they will also make an effort, it's not that they won't study, but if we in the class are also doing that comparative study, then definitely they will get a different dimension also. So that's why I also make sure that a comparative study is being done, and a comparison also with selected countries, not with all, like China or other this countries like that of UNIDO countries. If we can take, then that will definitely help them. Then coming to the various compliances, if we can develop a particular module on the various compliances under the labor laws, if there's a separate module on the various compliances under the labor laws, then definitely this will, what you can say, this will be a kind of checklist for our students, and this will help them to understand what all compliances, because basically they have to advise to their managers, or if they might be the managers of future, so they must have very much clarity on what are the compliances that they have to make when they are the owner managers of any establishment, so that there is no non-compliance on their part. Yeah, and then it is very, very important to include the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013. That necessarily, that is one of these important topic module that needs to be included in our syllabus, because our students should be sensitized with this also. Now moving to next, after discussing about the contents of our syllabus, this is basically, when it comes to law relating to wages and all this, I have just taken from the codes only, and this is what we have to teach the students. Now moving to the other courses that can also be designed, because labor law is such an area wherein, this is useful to many of us. In fact, every one of us, even if we are employee, labor laws are important for us. If it's a worker, labor law is important for him. If it's an, what you can say, even the managers, the entrepreneurs, the homemakers, for everyone the law is to be known. So we are very fortunate that we can have so many courses that we can design looking at the need of the stakeholders. So what I feel is that the diploma courses can also be developed in the area of labor law. Training programs can be organized, and these training programs can be for various stakeholders. Like right now, the training program for EPO officials is going on in our university, wherein the labor law experts are only teaching. So we can also organize these kind of training programs where the HR professionals and all others who must know about labor laws, all the compliances under the labor laws, for them the training programs, short training programs can also be organized. Short-term courses can be organized, because labor law and industrial law is such an area wherein everyone must be sensitized, everyone should have the knowledge. Certificate courses in labor laws and human resource management, that can also be designed in order to cater to the need of HR professionals, and many practical courses. What I was, just having a look at the list of books which are published and which are authored by Advocate H.L. Kumar. So he has, he has published multiple books on labor laws, and he has covered various areas, like, a book on obligations for the employers, book for compliances for the employers, book on termination of employment, book on disciplinary procedure to be adopted in the establishment. So many books available. It's such a practical subject wherein the practical courses can also be designed to deal with all these aspects, especially when it comes to obligations for the employer, especially when it comes to the disciplinary proceedings under the labor laws, and when it comes to termination, what are the rights of any employee. So these are various areas which are available in this subject, on which different courses can be designed. Now coming to the last part of our discussion, that is evaluation and assessment mechanism. And this is how we can actually assess our students, that the way we have taught them, whether they have learned the subject or not. So for that, I feel myself to be very fortunate that the subject is allowing me to have multiple exercises in order to assess the students. So when it comes to the evaluation and assessment, there can be practical and problem-based question. Here, this is a subject where even if we don't want to ask any theoretical question, we have the scope of asking many such problem-based question, wherein we can just frame a problem, wherein we can ask that whether the contract labor in this case, whether the contract is a sham contract, whether the who has the liability to pay the what you can say, to pay the wages to the work, to the contract labor, what are the violations when it comes to the provisions under the Contract Labor Abolition and Regulation Act. On the contract labor itself, I can frame a problem, and I can ask my students to apply the various provisions under the Contract Labor Abolition and Regulation Act. Similarly, on any other issue, like, notice, requirement of notice under the Industrial Disputes Act 1947, or the power of the court under Section 33C, 33C2 of the Industrial Disputes Act 1947, I have lot of scope under any of the labor law. And then when we talk about Trade Unions Act, I can just give them a problem wherein they have to decide what modes of collective bargaining will help the employer to settle the matter in this case. So there also I have the scope of giving them a problem, and based on that problem only I can ask them to apply the provisions of law and answer the questions. So this is one of the best way of doing the evaluation of the students. Then yeah, mood problems, that also one of the assessment mechanism that we as labor law teacher can very well adopt. So who says that there cannot be mood problems here? There can be a lot of mood problems here only on the basis of the problems that I was discussing just now with you. So either on those problems or on the basis of any such decided case also, the problem can be framed. The basic purpose is that the student should learn the skills. So mood problems, that can also be one of the assessment criteria. Then case analysis, because we have to understand that whether the students are able to do the case analysis or not. They are able to understand that what led to a particular observation by the court or decision of the court. Empirical study, as I was telling you, under the evaluation sorry, teaching pedagogy also. So empirical study is also one of the best way of evaluation, wherein a group of students can be formed and a small sample survey they can do, and on the basis of that they can submit the findings regarding any of the problem. Like I usually give them the very small problems, like just going out and identifying an area where the building and construction workers are working. So what are their problems, whether the provisions under the Building and Construction Workers Act have been complied with or not, what are the failures, what are the violations that they can very well do. So our subject is such wherein there's a lot of scope of encouraging the students to do the empirical study. So this is one of the best way. Then yeah, one more very innovative way can be to ask our students to do the impact analysis. Now the impact analysis can be of any law also, and it can be for any of the scheme of the government also. So for unorganized sector in India, there are multiple schemes which the government has come up in order to ensure that their rights are also protected, and there are certain social security benefits which are provided to the unorganized sector workers. Like few examples, two examples I have written on the slide. So the impact analysis of this slide, the impact analysis of this scheme, that also they can very well do. This will actually help them to learn a particular scheme of the government, with what objective it has come into force, and whether it is yielding the results or not. So that impact analysis will definitely be helpful to them, and this can also be adopted as one of the criteria for evaluation. Then sensitization program, since we from the beginning I'm discussing with you that the students of labor law, they need to be sensitized about the labor matters, the problems of the working class in India. Now whether they are able to sensitize other also or not, once they have learned. Take example of what we can say, maternity benefit act only, or take example of contract labor only, or take example of payment of wages only. So once they have learned the concept, their evaluation can be on the basis of whether they are able to sensitize others for that or not. So for that I allow the students to conduct the sensitization program for those who are in need of this sensitization. So this can also be one of the evaluation mechanism. And then yeah, since the subject is such wherein the skits can also be there, through that they can actually depict the problems of the workers in India, and that can be a very good mode of assessment. And sometimes they can also be asked to just prepare the video, shoot it, and then they can display it in the class, which will help the other students to learn. And this can also be one of the evaluation mechanism. So multiple opportunities are there when it comes to the assessment criteria for this particular subject. Now I think I have covered all which was required for the subject. In case if you have anything to add, I will definitely like to hear you.
Okay, thank you very much, madam. Any questions? You can raise your hand or you can drop the question in the chat box. Couple of questions were there. Okay, chalo, let us start. What the labor code not yet in force? What laws should be teaching our students?
Okay, so since the labor codes are not yet enforced, it's the existing law only which we have to teach to our students. But what I do is I keep on teaching them through a comparative study, so that whenever they will be out and joining the firms and all, at least they know the existing law also, and what are the changes being brought through these codes also. So as a teacher, it's our duty that we should update them.
Mhm. Another question, what is the present position of definition of industry?
What is the present position of definition of industry? See, after Bangalore water supply case, although the apex court decided to have a larger bench in order to widen the scope of the word industry, but since 1986 amendment also didn't come into force, so therefore whatever was laid down by the Bangalore water supply case, it is still in existence.
New labor codes are just the replica of older one. What's your take on this?
No, it's not like that. Although I agree that many of the provisions they have been just copied and pasted, but it's not the replica, because we can find out major changes being brought by these codes. So we cannot simply say, I mean, that cannot be a statement that it's completely the replica. Few provisions have been taken as it is, but there are some major changes also being brought. So as a law teacher, that's why I was saying I was telling you that it's a challenge for us. We have to clearly tell to our students that, yeah, this is the change which has been brought and why certain provisions are intact.
Okay. Another question, Indian economy is labor sensitive, yet laborers don't have any say in providing a direction. Can you point out the challenges that legal framework faces so that our student may bring out the change that NIEO has brought? What is NIEO? I don't know.
Okay, I can read it. It is here. Indian economy is labor sensitive, yet laborers don't have any say in providing a direction. Can you point out the challenge that legal framework faces so that our students may bring about a change that NIEO has brought? Okay, so yeah, I also do agree that the economy is labor sensitive, but laborers do not have the say because of the very reason that when it comes to the bargaining powers, the laborers, the workers do have that poor bargaining power. So that is definitely there. And when it comes to the legal framework, we all know very well that the collective bargaining is also not very successful in India. So that is one of the challenge that we are facing. Then even if we want that the workers should have a say, the legal framework itself is not allowing it, because we still do not have any such law which can give the recognition to the union. Had it been the situation that the unions could have been recognized through a law, I think the workers also could have got the scope of raising their voice through the unions, through the recognized unions. So this is something which is lacking, or it's a shortcoming in the existing legal framework.
Okay, let us take a couple of questions. So, what is your take on teaching this labor legislation when in the reality 93% of the labor force exists in unorganized sector? So, what's your take on this?
Okay, yeah, I totally agree that but when it comes to the organized sector, see, when it comes to the applicability, we cannot say that all the laws are not applicable to unorganized sector, isn't it? There are certain labor laws which are applicable both to the organized as well as unorganized sector. So definitely, I mean, when it comes to the teaching of labor laws, we have to teach them, although not applicable to these workers. We have to identify those provisions which are applicable to both the sectors, and accordingly we have to teach it to them. And this no more will remain a challenge which is there right now, because we have the another mechanisms available. When we will have these codes enforced, definitely the unorganized sector will also be covered. And there are still many laws which are protecting the unorganized sector, like when we talk about posh, even the unorganized sector women are covered. When it comes to maternity benefit act, we have to actually teach the students through the judicial intervention, because judiciary had been very helpful to the working class in India, especially when it comes to maternity benefit act. Now the condition there is also that it is only applicable to those establishments where 10 or more workers are working, which itself shows that it is applicable to organized sector. But if we look at the judicial intervention, There are many such cases wherein the court has intervened, and it is held by the court that even the daily wage earners, those who are on the muster roll of the employer, they are entitled to claim the benefits if they are fulfilling the condition of 80 days of continuous working. So, I mean, judicial intervention is there, and that definitely is to be taught to the students along with those laws which are applicable to both the sectors. What should be the changes required for speedy remedy for redressal of industrial disputes under ID Act? So for that, the Second Commission on Labor, it gave the recommendation in the year 2002 when the commission submitted its report that we should have one IRC, Establishment of Industrial Relation Council. This council will actually replace the other adjudicatory mechanism, and this will help in speedy disposal of the cases. So same also has been incorporated in our courts, and definitely this will give the relief when it comes to redressal of industrial disputes under ID Act. Ma'am, usually the students find labor law very dry subject, and teachers sometimes tend to make it boring as they are not allowed to teach, as you have emphasized, within the restricted scope. How can a teacher make the subject interesting for the students and also finish the syllabus on time? That's very easy. Even, I, some earlier, not now, but I used to feel that students are not taking so much of interest which they are taking in the other subjects. So that problem always lies there, but I then found out the ways of making the subject very interesting, like the documentaries and all. So as I said that there are so many documentaries, good videos available which can actually bring that sensitivity amongst the students regarding any of the problem of the workers. And we in the initial classes only we have to tell them that how vast this subject is, how important this subject is, how it can be helpful to you even if you are joining any law firm, or you are practicing, or you want to go for judiciary, or any services you join. You have to deal with any of the matter which is relating to the working class in India. And then we also have to tell them about the scope of the subject. If we are able to tell them clearly about scope, significance, and how it can be helpful to them in any career that they join, this will definitely generate the interest among the students. And then we should also tell them in the first two classes only about the career prospects available, that there is not a single option available for them if they are expert in the area of labor law. There are multiple options available for them in case if they have gained the expertise in the area of labor law. So if we are able to tell them about scope, significance, career prospects available for being the expert in the area of labor law, definitely they will start gaining the interest. And then you all know very well that media has great impact than what we speak through our lectures. So documentaries, video will definitely help you, and I have practiced it. I would suggest you that you all also start. You will definitely see the changes. Okay, there's another question. Okay. Just a second, I'll read the other questions.
Okay, there's your last question, participant. Please do not drop.
So what is the question, sir? It's
Is there a, like, is real in reality the maternity benefit
in
to
reality, the
informal
maternity
sector
benefit
is
to an
just a dream?
informal sector worker is just a dream, just written in paper without implication. No, madam, it's not like that, madam or sir. This is not like that. Judiciary has intervened, sir. So, in case if it has reached to the court, definitely the relief has been provided. And yeah, for informal sector, the problem is that they do not get the means or access to get the justice. That is also one of the problem which is there. So once you are a part of any establishment, definitely you get the proper mechanism. But if you are not a part of any system, you belong to informal sector, then it becomes difficult. And then the laws themselves have laid down certain conditions, like 80 days of continuous service. If she has rendered, then she becomes eligible to claim the benefit. These conditions are actually restricting their rights. Otherwise, there is no such restriction as such. Application of labor laws in says, yes, that was also one of the issue, but now the government is very proactive in extending the provisions even to the says, क्योंकि worker है, whether he is a worker of a says or he is a worker of any other establishment. This is what had been the approach of the government, and therefore they have been made applicable even to says.
Okay, I hope all the question have been answered. So thank you very much, madam. On behalf of the organizing committee, I'd like to thank you for sparing your valuable time. I can see you still here in office, right? So thank you. Yes, definitely, because we cannot have proper session from home because we have a lot of disturbance from there, and most of the faculty from I know from GNLU and other there took the lecture by sitting in their office. Definitely, I personally also can. I remember we were having only one paper in labor law. It was very difficult task, 10 plus laws, and some were not part of the labor. Only one paper, 3 year course. Nowadays, it's like 2 papers are there. So very difficult, I would say, because so many laws are there and to remember those things. But again, practical aspect, rightly stated. Recently, I was at GNLE for training enforcement, officers that so it was very great experience. So obviously we have to show we can become this, and then what are the future prospects in that particular field, whichever subject, labor law or any other subjects. So obviously we can, it's up to us, like we can try. Definitely challenges are there to make this particular subject interesting. So thank you very much, ma'am. Once again, I look forward to seeing future events. So thank you very much.
Thank you. Thank you so much, sir. Thank you for providing this opportunity. And it was really very nice to interact with all the participants. Very interesting questions they have asked. And that also has actually allowed me to learn the subject well.
So, thank you.
Thank you.